Yeah, absolutely. And we really appreciate you taking some time to join us and walk us through some of these things, because I think it'll be kind of procedural and a little bit geeky and insider baseball kind of stuff, but I think it has pretty interesting implications potentially. And so the main thing we're going to be talking about here is the fact that the Ninth Circuit did not accept a request to take this case, which has already had lower courts opine on it, to the full panel of the Ninth Circuit, what's called an en banc panel. And I think that has a lot of potential implications for the future of gun litigation in California and the rest of the Ninth Circuit, which is obviously very important because it's a major area of Second Amendment law in the United States. But first, let's talk a little bit about the background of this case, because I think people maybe forgot about this one a little bit. So it's made a lot of headlines when the law was first passed in California. This dealt with sort of advertising of guns that in ways that may, quote, appeal to minors. And at the time that this passed, it created a whole lot of confusion within the state, right? Especially among youth shooting organizations. So there's obviously, even in California, it's a very large state with a lot of people and a lot of gun owners. And a lot of them have children who like to participate in the shooting sports, things like clay shooting, especially is a very popular pastime in lots of parts of the country, but also in California. And there's been a number of very elite Olympic shooters who've come out of the state. I believe Kim Rhodey is from California, if I'm recalling correctly, who's one of the most accomplished Olympians in American history, in fact. But, the way this law was written, yeah, I know that it caused, we did a bunch of reporting on this at the time. It caused a lot of those shooting leagues that exist in California to shut down. It really handicapped a lot of the up and coming shooters, the younger shooters, including a 16-year-old at the time that we interviewed and profiled named Lola Fitzgerald, who was, one of the top youth shooters in the state. And she had trouble even participating in the sport once this law went into effect. And then you guys sued over it, right? Or a collection of gun rights groups that you represent sued over, like the California Rifle and Pistol Association that you guys do a lot of work with, and a number of other groups. What's happened since this first wave of attention and news where, these shooting sports leagues were impacted and shut down, magazines and gun stores and all this other stuff was impacted? What happened after that?
Well, you're right. So when the law was passed, it was called AB Assembly Bill 2571. And it was initially a really broad sweeping, I think intentionally vague bill that barred what they called, quote unquote, designed, intended, or reasonably appears to be attractive to minors. And it had a list of characteristics that make something reasonably attractive to minors. But of course, that list was not exhaustive. It was things like using plush animals to promote firearms sales or firearms organizations, using children, minors under 18, in advertisements or images, using colors or sizes or characters that would be attractive to youth. Without any limitation that those things might also be equally attractive to adults. And so what that initially did, which, as you mentioned, was it threw youth shooting organizations, all youth-oriented magazines, even some magazines that were targeted to adults that might have ads with youth in them, like a young person hunting with their father, for instance, which is an image you see a lot. In even grown-up magazines, that would have counted too. So there was a lot of concern, and it was passed as an urgency bill. So it took effect the day that Gavin Newsom signed it. It was immediate. And so junior shooting organizations, including our clients, the California Youth Shooting Sports Association and others, immediately put the brakes on the events that they were hosting, competitive shooting events, outdoor youth days where their sponsors are local shooting sporting goods stores. Those sorts of like outdoor, get it outside and enjoy the outdoors events got canceled throughout 2021. excuse me, 2022. I'm sorry. And then, and then some of these organizations, a lot of the sporting organizations, worked with some politicians in Sacramento to say, look, this is completely broad. It's not just touching commercial speech, and it's affecting our ability to have competitive shooting events for youth. And
right,
so,
right.
yes,
So there was a backlash to this
huge.
the initial selling point for this legislation from Governor Newsom was a kind of a troll campain from a single company, essentially.
Yeah.
We Won Tactical. They made a 22 long rifle that was designed for children, designed to have the appearance of an AR-15. They called it the JR-15,
Right.
and they used marketing that included, skull and crossbones with a pass fire, and this outraged the governor and led to this legislation, which seems to be sort of intended to address, I guess, that concern that he had over this particular company, which did eventually change its marketing.
Right.
But obviously, the backlash is that this had a much wider effect in practice
Yeah.
than some sort of messaging bill over a single company's advertising.
Right. And I think that, perhaps for certain folks who were taken aback by that particular advertising campaign, this bill was reasonable to them. But I think that there perhaps was some broader goal that certain, California politicians perhaps, saw this as an opportunity, because that advertisement itself, while, you can have your feelings about it, whatever they are, good or bad or indifferent, it was obviously a ploy to get at a broader thing that we're seeing in California, which is a lot of laws that are aimed at tamping down on gun culture generally. I also do a lot of lawsuits with regard to banning gun shows throughout California on state-owned property. And so, as we know, yes, that's a place where gun transactions are begun in California, ammo sales happen, but a huge portion of that is just coming together and celebrating gun culture. And so it's something broader that we're seeing, and that ad was just something that Newsom was able to use to start this. And so, yes, we ended up with this huge backlash. They tried to pass an amendment to the law, and they passed it rather quickly in response to our junior sports magazine's lawsuit. And they did some things to try and narrow the law a bit to make it so that these sorts of youth outdoors days weren't being impacted, that competitive shooting events could still happen, that you could have fundraising dinners where, youth guns might be advertised or sold or raffled or sponsored. And they tried to do that. And I think that the lawsuit does show, the outcome of the lawsuit does show that they were at least sort of, and the state was at least sort of successful in narrowing it to only that type of commercial speech, because it became, with the amendments, it became that it wasn't just, all sorts of pro-gun messaging that might be enticing to youth, but only when the primary purpose of that messaging was to sell a product that was, and it's not just firearms, it's firearms, ammunition, and firearm related products. And that is defined very broadly to include almost anything that one would use while shooting. So right. It's, so they were sort of successful in narrowing it.
So they passed this the legislation was passed on an emergency basis, and then they kind of went back on an emergency basis and tried to fix some of these issues. And it does seem to have had, like you said, some success. There, a lot of these shooting leagues are now back operating. Right.
That's right.
So yeah, I guess the question then is why did this lawsuit continue? Why weren't you satisfied with those changes?
That is such a good question. And I think the answer is kind of twofold. First, I think first, as I keep saying, I think it was only marginally successful in really limiting it to that type of commercial speech, because, as an attorney who represents organizations like California Rifle and Pistol Association and other organizations that do these sorts of youth outdoors days, sporting events, and even competitive sporting events, those types of events, as just like any event, festival or event like that, it has sponsors. And who are the number one sponsors of these sorts of events? They're going to be the manufacturers, makers, and retailers of firearms, ammunition, and any firearm related products as the law was defined. So in our view, my theory is that the law still impacts the ability of these nonprofit organizations to host these sorts of events for youth and families, where youth are trying their hand at shooting and other recreational activities, and for the higher level competitors to where the sponsor of their an Olympic shooter might have a sponsor, right, and he or she would not be able to wear their logos, right, because they are firearm related corporations that are trying to sell a product through that person. Also, those events, again, they're highly sponsored by those sorts of things. So it still shuts down that speech to adults and to youth. But the other thing is that even if we're only looking at the commercial speech aspect and the ability of firearm related industry members, I call them firearms industry members in the bill, the ability of firearms industry members, and that includes pro-gun nonprofits, right, who have a pro-gun message, they are included in this law. It still muzzles them from making speech that is, what do they call it, designed, intended, or reasonably appears to be attractive to minors. The law was purposefully and intentionally extremely broad on what that means, and there's no way to tell. I mean, no reasonable person can look and be like, well, that isn't also just as much or more likely to be attractive to an adult human person. Additionally, in California still, minors can legally use firearms. So there's this speech, the ability to communicate to both minors and their parents who may choose to have, to allow them to shoot, that's that speech, educating them about what's on the market, what are safer for children and younger, smaller people to use. That information needs to be able to get to them. And the bill, even if we're only talking about the marketing speech, shuts that speech down, and it prevents it prevents adults from getting information that they need to buy and make good decisions about the firearm related products they want for their children. And it also affects older children's ability. They're going to become adults soon, and they're going to have a full Second Amendment right to access those things, and they should be able to get the information, educational information about what's on the market. So that's why we continue the lawsuit.